Welcome to this week's TAL Update. I'm Dr. Joe Pojman, Executive Director of Texas Alliance for Life. Last week, the Center for Reproductive Rights, a New York-based abortion advocacy firm, filed a lawsuit on behalf of 5 Texas women and 2 physicians in a state district court. The suit is an attack on one of Texas' key pro-life laws, the Human Life Protection Act, which protects unborn babies from abortion throughout pregnancy and against other pro-life laws. The lawsuit claims that women have been denied abortions because the unborn child has a fatal condition or because the life of the mother exception in the pro-life laws is too narrow or unclear for doctors to treat women without fearing prosecution for performing an illegal abortion. First, on behalf of Texas Alliance for Life, our board, our staff, volunteers, and supporters, I wish to express our condolences to the mothers in the lawsuit. They tragically lost wanted babies through illnesses that even today's advanced medical science could not avoid. But what about unborn babies who are terminally ill? We here at Texas Alliance for Life recognize that some people would prefer the laws allow abortions when the child will die before or shortly after birth, cases that are tragic and heartbreaking. However, we do not support abortion to take the life of a child, even in these rare cases. Society should never advocate the taking the life of a child, even when that child is terminally ill. What about cases when the pregnancy endangers the mother's life? While also tragic, these cases are exceedingly rare. For example, one is the case of a pre-viable premature rupture of membranes, or PPROM, when the water breaks before the baby can live if born alive. For those cases, the Human Life Protection Act allows an abortion, quote, in the exercise of reasonable medical judgment, the pregnant female has a life-threatening physical condition that places the female at risk of death or poses a serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced, close quote. Specifically for PPROM, refusing to offer the option of intervention in this circumstance is not supported by any medical guidance or by Texas law because of the likelihood that PPROM could become life-threatening for the mother. Nothing in Texas law requires a woman's death to be imminent or her unborn child's heart to stop beating before performing an abortion to save that mother's life, which is what the lawsuit claims. Texas law is carefully crafted to allow doctors to treat women with life-threatening conditions promptly, without risk of civil or criminal liability. The life of the mother exception language is the same exception language the legislature put into the law in 2013 to protect unborn babies from abortion beginning at 20 weeks. No physician has ever been prosecuted for performing abortions to save the mother's life under that law. Furthermore, since the Human Life Protection Act went into effect in August 2022, elective abortions have dropped from thousands per month to 0. At the same time, doctors have performed a relatively small number of abortions each month for, quote, emergency and health, close quote, reasons, without any negative consequences. Tragically, some physicians caring for women facing life-threatening situations are not following the medical standard of care or state law, doing a terrible disservice to their patients. Texas Alliance for Life supports clarification of the medical emergency exception language in Texas pro-life laws. That clarification needs to come in the same way doctors are educated about other legislation affecting their practice in Texas, from their hospitals and the state agency that regulates physicians, the Texas Medical Board. Thank you for joining us. We look forward to seeing you next week.